Hello, my name is David Plater. I'm the Deputy Director of the independent South Australian Law Reform Institute based at the Adelaide Law School. We're presently examining the topical and important issue of powers of attorney. We're fortunate to have funding from the South Australian Law Foundation to undertake this important reference. The issues that we're looking at that raise this intersection between the medical and legal roles include: what exactly is capacity in relation to making a power of attorney? Should it arise at the making of the power of attorney or its later activation? Who should assess capacity? Is it a legal role or a medical role, or indeed a combination of the two? What should be the test for assessing capacity? These are some of the questions which we appreciate your input. And we're grateful today to be hearing from Associate Professor Bernadette Richards at the Adelaide Law School and Dr Chris Moy, President of the South Australian AMA, to speak in more detail about some of these topical themes.
Hi Chris, thanks for taking the time to talk to us and give us your thoughts on this area. So as you know, we're looking at powers of attorney, and one thing I would really like to start with is ask you, what is your perspective, from your perspective, what is the difference between a power of attorney and an advance care directive? So a substitute decision maker under advance care directive and a power of attorney.
So a power of attorney, as I understand it, is really to do with financial matters and decisions to do with money and signing things, official documents to do with financial matters, whereas advance care directive has to do with pretty much all the other stuff, which has got to do with for doctors, quite often it's end-of-life decisions, but it's also other things about questions about where a person would prefer to live, what their wishes are, what their values are, and the broader context, decisions about those sort of things.
And from a medical perspective then, if you were asked as to whether a power of attorney should be activated at this point in time or a substitute decision maker should be activated, would you say they're the same, conceptually the same ideas, or are there different levels or different questions around capacity that you would ask?
They are different, although there may be overlaps. So for example, there may be an overlap in a decision to do with somebody moving into a nursing home, for example, or moving house, for example, because obviously there may be financial and lifestyle decisions and where somebody wants to live. But ultimately, the decision about power of attorney has to do with the financial matters and whether the individual is able to make decisions about those financial matters, and at the point at which they cannot make that decision, whether that decision making needs to be transferred to somebody else. In regard to where they actually want to live and whether it's actually really what they want, that's got to do with the substitute decision maker and the advance care directive.
Okay, and what are the sorts of things that you would be looking for if you're assessing capacity? I'll start with the activation. At that point where your patient potentially needs some assistance in decision making, and you're either been approached by the family or you're thinking that this person really shouldn't be in control of their financial affairs any longer.
Sure, look, and that's probably a good question, because that's something that has changed in my mind for a long time as I've got to understand this. And I think when I first started in medicine, I probably came from a very process-driven, medicalised view of it, which has got to do with notions of doing things that are medically defensible, and that's actually got to do with duty of care to a patient. And I probably had less concern about whether the patient, what the patient really wanted initially. And now I've come to the point where I think I have a much better understanding of that, which is really that decision-making capacity has got several elements. Basically, in terms of decision-making capacity, a person has to tick off on 4 things. They have to tick off on the ability to understand the information that's given to them. Number 2, they have to be able to keep it in their mind long enough to be able to make a decision. They have to be able to weigh up the decision, that is, apply the risks and benefits to come up with a decision, and they have to be able to express the decision in some way. I also understand that decision-making capacity is different to the way I thought of it when I first started medicine, which is that it's something that's presumed. You presume it first, and you have to actually presume them innocent, And whereas I think when I first started in medicine, it was more a matter of that it was almost a right to, that they had to prove to me that they could make a decision. It's the other way around. And that it's decision specific. It's about the decision that has to be made. So that they really, I think in the past it was kind of a thought that it was a global decision. If they couldn't make one decision, therefore they couldn't make any decision, or they had dementia and they couldn't make a decision, or they had a blood alcohol over 0.8, so they couldn't make a decision. But now I understand that in fact we really have to be able to apply the test of those 4 things for the person at the time about the decision that really needs to be made.
I'd just like to pick up on one thing that you said there. You were talking about decisions being situation specific. What's your understanding then if you assess someone as lacking capacity and this what we call activates the power of attorney? Is that a final decision, or is that something that someone can come back and revisit with you? What's your understanding of that?
There's probably 2 parts to that. The first is that we do understand that decision-making capacity for an individual will vary over time, and they'll have some individuals, for example, with dementia or have, say, mental illness or disability, may in fact fluctuate in that decision-making. So we do need to keep in mind that we've got to sort of try and assess it over time, and maybe assess people 2 or 3 times and try and pick them up on a good day, because that's what we want to do. We want to give them the best chance of making a decision. That's one thing. The second thing is about the decision-making capacity. It's about the decision that has to be made. And there is a bit of confusion about that. Certainly, so that's understanding that people can make decisions about some things but not others. Certainly, I think one of the best examples was Hazel Hawke. She might have, and I remember seeing her the first time, and she came out and said she had dementia, and I thought you wouldn't be able to tell actually, but she just had some short-term memory loss. But on a day-to-day basis, if you asked a question, she could have actually made the decision. The next thing is about what it's about, and I think there's confusion, particularly with power of attorney, that for example, the individual has to be able to know everything about their finances, for example. It's about, that in, say, appointing a decision maker, that they have to be confident that person at the time in appointing a decision maker has to know all their finances, when in fact they don't actually. What they need to know is the person they trust to be able to make those decisions for them. And that's the decision that needs to be made. And so this is the specificity about the idea of making sure that you know what the decision has to be made. It's not in that situation, in appointing a substitute decision maker, a power of attorney, about that individual knowing all the finances they have, because quite often I won't on any given day. It's about knowing who that individual would trust that they would appoint as a power of attorney.
Okay, so that's what we're talking about, the capacity and the actual appointment of the power of attorney. What is your understanding of the effect of activating a power of attorney?
Well, in terms of activating a power of attorney, what I'm doing is I'm making a decision about their ability to make it for that period of time. And because I understand that there may come another time that they will be able to make a decision. So whenever I'm making a decision about that, I will first up maybe make a couple of assessments and say that on these days I saw an individual and they were able to tick off on these 4 things about a particular type of decision that's about to be made, and that's at this time this is what I feel. Now that doesn't mean it's going to be a blank carte blanche for forever, and certainly that can be questioned later, that say an individual has a mental illness or delirium, for example, so a period of time they can't make a decision, they will be able to regain it, and then the power of attorney at that point ceases because the individual has regained decision-making capacity.
As we've been discussing, there's 2 key points in time with the power of attorney. There's that point in time when the document is actually executed or written, and then of course there is that point that we've been discussing of activation when it's decided that the power of attorney steps in on behalf of your patient. Or the question that we are considering is, who should assess capacity? at the time of execution, is it okay that a lawyer assesses capacity? Is this a legal question? Is this something that perhaps someone should go and see a GP or another healthcare provider? And again, at activation, who should assess capacity or lack thereof?
I don't think there's an absolutely clear answer to that question. I think I think most times it's pretty obvious, and there may not be a requirement for a doctor to be involved, but sometimes there may be some question about an individual's decision-making capacity, and you may need to involve either the normal GP of an individual, or maybe potentially escalate it. Particularly, and I think to some degree, unfortunately, the stakes matter in terms of potential issues about conflict in a family, for example, with regards to the financial implications for that individual. I think they're all things that need to be considered as far as the execution of the document. In terms of the activation side of things, look, in most situations, I suspect the person to do it is probably the GP. The GP does probably have an advantage in most situations of having some history with that patient, and will firstly understand the circumstances. First up, potentially the sort of the psychosocial background and potentially if there are complications in what's been going on. And to be frank, sometimes they will understand if there is attempts of manipulation of the decision. The other thing is that they will have seen their patient for a long time, hopefully, and have an understanding of where they've been and where they are, and if there's a big change. Again, sometimes, and that doctor should probably do an assessment over 2 or 3 visits quite often. That'd be a bit of what I'd do. I wouldn't rely on just one visit usually, unless it's become obvious to me over a period of time that has been the case. The person had lost decision-making capacity. It was quite clear. Again, though, sometimes there will be situations where the stakes are quite high. There are potential for manipulation. Pressure on the doctor. I think that's probably quite a good test, actually, if there's pressure on the doctor in that situation, to maybe involve somebody else and get a second opinion, and that may be a specialist opinion then.
I'm just interested to know, what would your instinctive response be if you read tomorrow that it is now enshrined in the law that you need to have medical assessment for both execution and activation of a power of attorney, that there's absolutely mandated medical involvement?
I think the first thing is that I'd be concerned a little bit that it's a medicalised issue. Decision-making capacity is not a medical issue, and that's actually a fundamental misunderstanding. It's a decision about whether you can make a decision. It's not whether somebody has a blood alcohol of a certain level. It's not their mini-mental score. And I think sometimes just focusing on the medical side of things risks the idea that it's a medical issue in itself. That's number one. Next thing is, a lot of times it's going to be self-evident, and involving medical practitioners for something that's pretty damn obvious is probably not going to be required. And also a waste of resources as well. I think there are. I understand, for example, that there are ideas that everybody, in terms of activation or execution, needs a specialist neurologists or geriatrician. There are not enough geriatricians or neurologists in the world to be able to do that. And if they do that, they won't be doing any other work, because this would be such a common thing. So we need to somehow get a balance in this and understand that, look, there's nothing perfect about it. I do understand decision-making capacity isn't perfect. All we can do in the world is do the best we can with what we've got, but try to sort of tailor the decision-making and who needs to be involved with the level of complexity of the decision that needs to be made at the time about whether somebody has decision-making capacity and whether they can fill out one of these forms or activate it.
Yeah, so your concerns are it's over-medicalising, burden on resources, and not really addressing the key question.
No, because I think, to be frank, sometimes, I said before, I think I've come from this myself. It's this idea, we do come from a very, that it's a medical issue, that it's a duty of care, and we come from a medically defensive point of view. We don't come often from the idea that decision-making capacity is presumed, number one, and that it isn't just a score or a test that we can do. It's these more difficult things about whether you can tick off on the four things, and to understand that it can fluctuate, and it's about the decision and really that high level stuff about really being able to dissect out what decision. It's not knowing about the decision about which shares, every single share. It's about really who you trust to make a decision, for example, or whether that individual is able to make global decisions about that type of call.
You're clearly interested in this, but I'm just wondering more broadly, why do you think that this power of attorney and this reference and investigation that we're doing is important in the medical profession?
I think this gets to the nub. We talk so much about things like self-determination, okay? And we say, look, it's really important that we give self-determination to our patients, but the first thing we do is sometimes take it away from them. And I think really we've got to look into ourselves. What would, as a doctor or another health professional, what would we want? And we only would want it taken away from us when really it's supposed to be and when we can't make that call. And so I think for having seen the journey that I've been on, the misunderstandings that I've gone through about decision-making capacity, and I'll tell you that when I first started, I think I would have been the first to take away the self-determination of a person, because I think my threshold would have been quite different. It would have been very much, well, they can't make a decision, they've got this mental illness, they've got a mini-mental of this, look, that's it. Cut the line off. But really understanding that that's not, it's completely the wrong way around, in fact, and that we need to get away from just this very process-driven, medically defensive, duty of care type thing. Understand those, they're always going to be part of our world, but balancing with the fact that we need to really consider whether that person can make that decision and what the really fundamental elements are, those 4 things, and can they wait till another time, and is it really about the decision that needs to be made?
So from what you're saying, there's potential for misunderstanding about the roles of these decisions and the impact of these decisions and the processes that you must go through in making a capacity assessment. A recurring theme when we've been talking to some other parties has been really around the need for some education. Would you support that, do you think? Is there a gap? Is there a knowledge gap?
There is. There is clearly a knowledge gap. That needs to be filled in from the very start, probably at medical school level, I think, and we need to drum into this fundamental, because this issue about decision-making capacity flows right through your world. Pretty much every decision about consent right through your medical career, and we need to start working there. And then potentially increase the information out there. So we balance that up against the sort of very process-driven, tick the box type medicine that we do at the moment. So, I mean, we've looked at, for example, things like, a pathway for management of stroke or dementia. We really need to somewhere insert the need to actually decide whether somebody can make a decision about consent somewhere along the way. And part of that is obviously decision-making capacity, because that is really the line. That is the line at which, so much flows out about who makes the decision about consent, about power of attorney, about the future wishes of an individual, their residential matters. It needs to be embedded, and I don't think we've done that. And I think potentially it can also be embedded in other things like the forms that we fill out. A lot of the forms assume that the person filling it out can make a call about decision-making capacity, and I think it's possible to do that. There are documents, I think, that have been looked at for decision-making capacity before the institution of chemical restraint, for example, in a violent situation in an emergency department, and the sort of things we've talked to legislators about is maybe embedding the actual decision-making capacity test into the document to make sure that the person is actually focusing on those 4 things as they fill out that form, so that they're actually genuine in making sure that that is the case, that those things are being ticked off in their minds before they actually make a call.
So it is incredibly important, but what about this inquiry that we're conducting? What would you say to your colleagues about getting involved?
Yeah, please get involved, because I'm sure that for many of my colleagues, some of my colleagues may be quite upset with the sort of things I've said. When I'll say that, I've been on that journey myself. I remember being quite upset when I remember a time when we were talking about just a made-up case about somebody who had I think anorexia, and that it was a matter of whether we could decide on making a surgical procedure to force feed her. And I remember 20 odd years ago in a meeting saying, well, it's pretty obvious duty of care means I have to put a tube in. And I realised that, now looking back, how really, and I was quite angry and frustrated that nobody else in the room understood that. I understand it now, that we didn't get past first base about the critical point, which did that person have decision-making capacity, and did that person have the ability to refuse treatment? And obviously that was about a medical treatment, but decision-making capacity flows on to so many other things about consent, and also obviously matters of financial matters in power of attorney.
So this is something that is incredibly important in the day-to-day conduct of healthcare, as you've highlighted throughout our discussion. So for it to be left in the hands of lawyers or scholars is perhaps ill-advised. We do need some medical...
We do, because it has to be brought back to reality, in the day-to-day reality, our reality, fit in with our time, our workflow, and understand that there's also, in my world, very limited resource. This is not just an intellectual exercise. It can't be, because the hard-nosed coalface out there is of a really rushed work day where decisions are made under pressure with not much time, and there are actually very limited resources, especially as you increase into increasing specialisation. So we have to try and get the right balance in this, just like most things, and apply, unfortunately, some common sense, whatever that means, to try and find the best way forward. Nothing's perfect, I get it, and there are always going to be potential for errors one way or the other in matters of decision-making capacity, but gee, what we can do is try.
Thank you for everything that you've had to say. That's just amazing. Very, very important and incredibly insightful. One last question, I guess, is from your own personal perspective, is there anything that you would like to add? We've
spent careers, on focusing on, people have focused on, making sure that they provide good care, that they can offer wonderful treatments to their patients. Many of us as health professionals have done huge amounts of research on really amazing treatments, but all of that is irrelevant if at the point of care we cannot, number one, clearly articulate to a person what the pros and cons of a treatment are, but also determine whether that person can make a real decision. And that if we don't really understand when a person cannot make a decision, then we've actually defeated everything before it. Because it's kind of irrelevant, because if we can't actually decide whether somebody has decision-making capacity and whether they can really make a decision, we haven't really done right by that individual at all.
I thank you for your interest in this reference and the Institute. Please feel free to contribute to our work via our website and our email that now appears on the screen. Thank you.